Good afternoon, everyone. My name is Lluc Cerda. I'm the managing partner of the Calgary office of Samfiru to Markin, the Western Canada practice leader for employment law. Thanks for joining the show. We are here today to discuss your employment rights. We're here today for the next half hour to answer any employment law related questions that you might have. It's as simple as simply putting your question in the chat, and we're going to get to as many of them as we can today. I was recently being asked a question. A gentleman had a situation that was quite unique. Tell me what you think. A situation where this gentleman had been put off work by his doctor, couldn't go to work as per a doctor's note. The disability provider, though, did not think that this person was disabled within the meaning of their policy. And the employer decided, well, now you got to come back to work. And so basically, the employee was in a tough spot because the doctor was ordering them not to go to work, and the employer was ordering them to go to work. And the employer was saying, if you don't come to work, we'll consider you to have abandoned your position. All right. And so the question is, is the fact that you're not going to work because of doctor's orders, is that abandoning your position? Basically, abandonment is a form of kind of resignation. If you don't show up to work for a certain period of time, it could be that you're deemed to just have abandoned your position. The test to determine whether you've abandoned your position is objectively, does it seem like you've decided that you're not coming back to work? You don't want to work here. You're basically resigning. You've moved on with your life. Here, what I recommended to the employee is that get in touch with your employer. Tell them this: I'm not abandoning my position, despite what you say that you're going to deem that I've abandoned my position if I don't show up to work. Contact your employer. Tell them, no, I'm not abandoning my position. I'm following my doctor's orders. If you need further medical information from my doctor, go ahead and inquire. Happy to provide the medical information you require to make your assessment. But I am not abandoning my position. I am being told by my doctor not to go to work for medical reasons, and I'm following my doctor's orders. All right. And from that perspective, it's very hard to objectively say that that employee has abandoned their position. Why is that? Because they've explicitly told the employer, I'm not abandoning my position. Right. I am happy to return to work once I'm medically cleared to work. All right. And I'm happy to get you the information that you need should you require additional medical information to assess as to whether I can be accommodated at work or whether I'm restricted from going to work due to medical reasons. So that is my advice to you. If you are ever in that kind of no-win situation, where you're being ordered by your doctor to stay off of work and you're being ordered by your employer to show up to work, because in the middle is an insurance, a disability insurance provider that's decided for God knows what reasons that you're not entitled to disability benefits. All right. If this ever happens to you, it's a bit of a tricky area of law. It's important that you get in touch with us so that we can help you navigate this. Because if you don't want to lose your job, it's important that you follow the right steps. Simply ignoring your employer's request that you attend work is not the right approach. Rather, you want to keep those channels of communication open and ensure that your employer knows that you are fully intending on coming back to work when you're medically cleared to return to work. So if you're wondering, well, that's the situation I'm in, or someone I know and love is in that situation, and you want to get a little bit more help from us, to reach out to us is very simple. Simply go to employmentlawyer.ca, employmentlawyer.ca, and we'll be more than happy to discuss with you, with your loved ones, the situation that we're in, to make sure that you are not left alone in this time of need, that you can figure out the best way to move forward and protect your legal rights. We have a question coming in from Peter from YouTube. Peter is asking, I work for a large corporation in Canada, and my doctor recommends an 8-week medical leave for treatment. During onboarding, my manager warned that using medical leave would mean losing my job, though I'm unsure if that's company policy or just their opinion. I know medical leave is protected, but I've heard of people being let go right after returning. What can I do before taking leave to protect my job and prepare in case they tried to replace me. So there's an unfortunate reality that sometimes employers flaunt the law. All right, because you're right, Peter. You are protected if you need to take a medical leave. You are in Alberta, BC, and Ontario. There are such things as job protected medical leaves that allow you to get treatment if it's required, and that allow you to be off work while you're unfit to work. Okay, and that's under employment standards legislation, and it's under human rights legislation. And both those legislations indicate that if you are terminated for having taken a medical leave, you have the right to be reinstated into your position. So it's not just that they owe you severance. Oh, well, wash our hands. You were only here a few months. We'll give you, a couple of weeks severance. That's all you're owed. And we're done with you. No. You're entitled to be reinstated into your position with back pay. All right. So if it takes a little while for, the tribunals to order that you be reinstated, well, you're not out of pocket. You're entitled to your full lost wages from the time you were terminated until the time you're reinstated into your position. So you might be someone that's only worked somewhere for a few months before you need to take a medical leave. If you were just going after your severance, you might not be entitled to all that much. But because you're entitled to back pay, you're entitled to quite a bit of compensation potentially on top of reinstatement. All right. So if this is something that has happened to you, or if you're concerned that this is something that they might try to do to you, Peter, it's important you get in touch with us to ensure that your job is protected and that you have a job to come back to once you're cleared to return to work after your medical leave. So if you're looking to reach out to us, we're at employmentlawyer.ca. You have the website right there on the screen. Feel free to reach out. We'll be happy to discuss with you. We have another question coming in. I'm seeking legal advice because my former employer is threatening legal action after I resigned early from a toxic job, claiming I broke a contract I don't recall signing, citing a non-compete with insert name still in it. Okay. Doesn't that make it unenforceable? They're also demanding I return my personal phone and threatening to withhold my pay. Can they legally do any of this? Well, actually, they can't legally do any of it. Okay. So they're in a bit of trouble. So here's how to unpack it. Okay. So firstly, if they withhold your pay, the first thing you do is you call employment standards. Okay. Employment standards will investigate as to why they're withholding your pay. And if they're withholding it without good reason, which you not giving enough resignation notice is not a good reason to withhold your pay. So if they're withholding your pay for vindictive reasons, employment standards will order that they pay you your wages. Okay. If they are saying that you are bound by non-compete agreement, well, firstly, I would have to tell you we'd have to look at the non-compete agreement to ensure its enforceability. I can tell you in Ontario, almost all employees since 2021 are not bound by a non-compete, can't be bound by a non-compete agreement. All right, non-compete agreements have basically become illegal in Ontario since 2021, October 2021. In Alberta and BC, it's different. There theoretically can be non-compete agreements, but presumptively they're unenforceable, which means it's the employer's burden to prove that that's an enforceable non-compete. In this case, it doesn't seem like you've actually breached any, you're not competing, you just have resigned without providing what they consider sufficient notice of resignation. So theoretically, if you don't provide sufficient notice of resignation and your employer suffers losses as a result, they can sue you for that, okay? Theoretically, just as you can sue your employer for not providing you with enough severance, all right? In actuality, it's very hard to sue an employee that's not a very senior employee, like a CEO or a senior vice president. It's very hard to sue someone that's more of a regular employee for not providing enough notice, because whatever losses the employer might be able to prove that resulted from you leaving the job early are offset by the salary savings that they save from not having to pay you during your resignation notice period. Okay. And so it's actually very hard for an employer to prove it. So what I see a lot, in fact, are very vindictive employers who decide to, rattle their swords and scare you out of looking for work by threatening legal action. All right, and it's in fact, in actuality, when you look at the merits of the case, there's not a lot there to it. So if this is something that's happening to you, better to get a lawyer on early who can send, one strongly worded letter explaining what I've just explained. But there's usually not a lot of grounds for an employer to be threatening litigation against an employee and kind of trying to leverage the imbalance of means between the parties. That's not going to be looked at very favorably by a judge. Okay, so get us involved early so that we can push back and let them know, listen, that's not going to happen. You're going to be able to look for a job in your chosen profession without fear of reprisal from your former employer. All right. So if you're looking to reach out to us to discuss this kind of situation, reach out to us. You have our website on the screen. It's employmentlawyer.ca. We have a question coming in from YouTube from Dusty338. I was injured at work and now disabled. I missed shift during my return to work plan through WCB, and my employer is cutting off my benefit coverage because of it. Is this a constructive dismissal? I'm not exactly sure what is happening here. So I missed shift during my return to work plan through WCB. So my understanding is that you were some sort of graduated return to work plan, and for whatever reason you missed some shifts. But if you're getting WCB benefits, I don't understand how you're also getting LTD or other benefit coverage. So if it's not LTD coverage, is it just like health and dental? I really don't have enough information to understand what you're going through here. But generally, cutting a component of your compensation can be a constructive dismissal. So that's kind of what I'd be leaning towards. I just don't have enough information of what benefits are being cut here, whether it's your WCB benefits, whether it's the top up to the WC benefits that you're receiving. So maybe you want to provide a little bit more information and the reason why you missed some shifts. I might be able to answer that question a little bit better, Dusty338, but right now I don't fully understand. I have a question coming in here from Sandy K2HH. For a former employee in Fed Reg situation, can the company deny my request for payroll records from 2 years ago as we go into mediation? I don't see any time limits in the labor code. So depends kind of where you're at in the litigation, Sandy. I can tell you that my understanding of the labor program, which is the Employment Standards Department for the enforcement of the Canada Labor Code, my understanding is that there is a requirement that you produce that your employer produce payroll records on request. My understanding is that for these kinds of things, though, the labor program can only go back 6 months. So if you were to request those records through the labor program by making a labor program complaint, it's possible the labor program, even though they grant you your complaint, can only go back 6 months. Okay, that's number one. Number two, if you're involved in the litigation process through the court action, if the payroll records are relevant to your litigation, then generally an employer will have an obligation to produce those records if you request them. All right, so that's kind of the way it is. I often find myself with clients that are like, well, all the evidence that I will need to prove my case is in the employer's control, right? They cut off my access to emails. They cut off my access to the payroll system. They cut off my access to all this information that will help prove my case. So what can I do now? All is not lost, okay? In the litigation process, employers and employees have an obligation to disclose any relevant information that they have, whether it helps their case or hurts it, all right? So employers can't just, destroy or delete evidence that hurts them, and they can't hide it either. They have an obligation to produce it. And you, if you know you sent that email or received that email that's the smoking gun to your case, you can definitely require your employer to produce that email. And if for whatever reason they're saying that email's been destroyed, it can't be found, or what have you, then a judge is going to look very poorly on an employer saying that key evidence has been destroyed or can't be located. All right. So definitely in the litigation process, you can require that information to be disclosed. So Sandy, what I would say is I wonder what kind of mediation you're going to. Is it a labor program mediation, or is it a mediation through the court system? Either way, I would say make the request informally, and then formally you can follow that up with either a labor complaint, a labor program complaint, or making a request through document disclosure requirements in the court action for those records. Ken O'Keefe one asks, BC has been on the job for 10 years. Sorry, I missed one. Sorry about that. I1U is asking, I was fired after taking a sick leave that was recommended by my doctor. What do I do now? Well, first thing you have to do, is contact us. All right. So reach out to us, employmentlawyer.ca. If you were terminated for having taken a sick leave, you have substantial entitlements to potentially be reinstated to your position with back pay, as I was explaining earlier in the show. So it's a completely different concept of severance. All right. Severance is basically, you're terminated on a without cause basis. We're going to look at four main factors to determine how much severance you're owed, which are your age, your length of service, the seniority of your position, and the availability of similar work. Okay, so you have a certain profile. We look at people with similar profiles that have received their severance through the court system, and we give you something similar to what they received. All right. Now, in another scenario, you might be a very short service employee. You've been there a few months or just a couple of years. Generally, those people don't get a lot of severance. They're not necessarily going to get the full 2 years. That is the kind of maximum, the upper limit of severance that you can receive in BC, Alberta, and Ontario. Okay. But if it takes 2 years for a tribunal to order that you be reinstated, or even longer, if it takes 4 years, I've seen it happen. It took 5 years, I think it was, for an employee to be reinstated after she was denied, not allowed to return to work after a leave into an accommodated position. It took, I think it was 5 years. She was awarded $400,000 because of the fact that, she's entitled to the back pay. She was out of work for 5 years. Back pay for 5 years amounted to $400,000. All right. And she was reinstated into her position. Okay. So that's what you might be up for as well, I1U. You might want to get in touch with us, employmentlawyer.ca, so that we can determine if the sick leave was a reason why you were terminated, and if so, how do we get your job back? The sick leave could have not been a reason. I've seen it happen. For instance, that an employer takes the whole department and shuts it down, ships that department's job overseas, for instance. And in that department, there happens to be someone who's on medical leave or on maternity leave, and they get terminated along with the rest of the department. All right. So for them to be able to have a claim to discrimination, they have to prove that the leave played a role in the termination. But if the whole department was moved abroad, then it's hard to argue that the medical leave or the maternity leave had something to do with it. Okay, but there are other reasons where we have a department of 8, we have to get rid of 3 people. We take the 2 oldest people plus the one that's on maternity leave. You guys are gone. Okay, that's potentially age discrimination and gender discrimination, right? Because you looked at some people's protected factors to decide who gets terminated and who stays, right? So there you have it. We have another a question coming in from Ken O'Keefe, one who's asked, BC has been on the job for 10 years. How soon do I need to submit the resignation letter to the employer? So most employees can give 2 weeks notice, okay? If you're starting to get into management or senior management, then it's potentially a bit more, okay? Most employees can give 2 weeks notice. Their contract might say something different. Their contract might say, well, you need to give 3 weeks, you need to give 4 weeks. If that's the case, give whatever you agreed to in the contract. But most people don't have employment contracts that address this, all right? So give 2 weeks notice. I generally recommend, if your employer comes back to you and says, listen, Ken, there's no way that we can transition your job in 2 weeks. Can you give us 4 weeks? I would say work with your employer, right? But if you're telling me I'm the CEO, I've been running this company for 15 years, I want to give 2 weeks notice. No, I would say no. Talk to the board, say, listen, I'm resigning, I'm retiring, I'm doing whatever. We need to figure out a transition plan so there's someone at the head of this company who knows what they're doing to steer the company through this process, all right? So you might have to give a bit more than 2 weeks in that case, all right? All right, so Dusty338 is providing some additional information. So more info. The employer is cutting health and dental coverage because I didn't meet minimum hours threshold. They keep pushing me beyond my limitation and I miss work following doctor's advice. Follow-up question. Employers are cutting off health and dental because I missed shifts on doctor's advice. My WCB claim has ended, but work keeps pushing me beyond my limitations. All right, okay. So listen, for it to be a constructive dismissal, Dusty, the employer has to be doing something that is not contractually allowed, right? They have to make a substantial change to your employment conditions without your consent. So if there is, for instance, a threshold amount of hours that you have to work to access benefits, and that, say it's 20 hours, you have to work 20 hours a week to access benefits, and you've now, for whatever reason, you've fallen down to 15 hours a week, and so they decide to cut your benefits. If that's been kind of automatic and well followed for everyone, and including for yourself, then that's not a change. They haven't changed the contract. They were just implementing the contract. If, however, this is nothing you've ever heard of, that part-time employees don't get benefits, and they can't show anywhere that you agreed to this, then yes, potentially it is a constructive dismissal. Absolutely. I mean, you're probably right now most in need of your health and dental benefits, given that you're coming back from a workplace injury. Absolutely. And especially if it's on doctor's orders that you're being required to miss work. Now, Dusty, I want to preface this by saying, listen, I haven't reviewed your benefits policy. I haven't reviewed your employment contract. It would be important that one of us at Samfiru Tumar can do that before you jump the gun and walk into your employer's office and say, I'm quitting because you've constructively dismissed me. Okay, got to do a little bit of due diligence to make sure that this is what happened here. Okay, that you've been constructively dismissed, and it involves going beyond the emotion and looking at what the contractual agreement between the parties is. Okay, so definitely want to look into that. So if you want us to review these documents, and I think you should, and give you a game plan if you are looking to claim constructive dismissal, then I would say reach out to us. You have the website on the screen there, employmentlawyer.ca. All right, that's how you reach out to us. So once again, my name is Lluc Cerda. I'm the managing partner of the Calgary office of Samfiru Tumarkin, the Western Canada employment practice leader. I've been here for the last 25, 26 minutes answering your questions related to employment law. I have time for one more question, but don't despair if you don't get your question in, because we have another show as soon as tomorrow. We have my colleague Sefton Liebrandt, who will be joining us at 1 p.m. Eastern Time to answer all the questions you have related to employment law. So don't forget to tune in. Last question is a follow-up question from Sandy KU2HH. Follow up on the payroll file. This is the person who was asking you for 2 years of pay stubs. Okay. Yes, mediation via the labor program. Employer has refused to provide records since 2023, claiming they have no legal obligation to keep them despite labor code and the HR policy. Okay. Well, they do have a legal obligation to do that, and it's in the labor program. And if you are, I'm not exactly sure why you're in mediation, if you've brought an unjust dismissal complaint or what have you. If in the unjust dismissal complaint regime, there is also an obligation to produce documents once you get out of the labor program potentially and go to the Canadian Industrial Relations Board. Okay, so if you're in, if you have a dispute such as an unjust dismissal complaint, the labor program is going to try to resolve it informally. And if they can't, they will refer it to the CIRB, the Canadian Industrial Relations Board, for a hearing. Canadian Industrial Relations Board is like a labor board. It's like a tribunal. You will go to a hearing potentially and have a vice chair render a decision. Okay, and the decision has force of law, just like a court order. Okay, the vice chair has the power to order production of documents. Just like a court judge does, all right? So if this gets to the CIRB and they're still saying that they don't have an obligation to produce the records, you can ask the CIRB chair to produce those records. If you are unable to know whether you are entitled, how to mediate a settlement without looking at those records, then you're kind of in a bind. You can't settle at mediation. That's kind of the situation you're in. You don't have the information that's required. I find it highly unusual, if not to not say suspicious, that an employer is refusing to disclose documents that they are not denying they have. They're like, yes, we have these documents, but we're not required to produce them. These are records that are your records. And you could potentially make a freedom of information request as well for these records, all right? So keep that in mind as well. If you're in the federal program, you might be able to do it that way. So I find it's highly unusual that an employer would refuse to produce those records. Is my view of it. And on that note, that's the show for today. Thank you all for tuning in. Some great questions today. Really enjoyed all your questions, and thanks for tuning in and listening to each other's questions and answers. If you like the session, like it. Don't forget to leave a like and a follow. And we are back tomorrow, as I was discussing, and we will see you then. Join us tomorrow with my colleague Sefton Liebrandt, where we'll be answering more of your employment law questions.